We are back, and it's Low Logs right here at Hope at Dawn, right here at Hope TV. This is where you look and live. And we told you that once we are back, we'll be having our guest in studio, and she is here. Her name is Martha Musimbi. She's an advocate of the High Court, and today we are looking at mediation in dispute resolution. And without much ado, why don't we get to know her even as we start our conversation this morning? Good morning.
Good morning to you, George.
Welcome.
Thank you for having me.
And it's a pleasure to have you this morning.
It's a pleasure to be here.
Osha.
Thank you so much. Thank you so much. It's not all that though.
Yeah.
No, it is
I've really tried to tone down. Yes. I've really tried. Can't you see I'm missing something?
Oh no.
Yes.
You mean you're missing something?
Yes, I'm missing some things. I don't have a watch, you know.
Yeah.
I've removed my glasses.
Oh, you look good.
They look
Thank you. Thank you so much.
Welcome.
Thank you so much.
Yes.
So
Yes,
brief
it's a pleasure.
introduction of Martha.
Yes.
Yeah.
So Martha, my full name is Martha Musimbi Amadalo. I am a lawyer. Actually, I'm an international lawyer. And I'm also an alternative dispute resolution ambassador. I'm a peace ambassador, and by extension, I'm also a mediator. I'm a court annexed mediator at the judiciary, that is at the law courts of Kenya, and I've been mediating for a while. And I also do other things, aside from just being a lawyer and being a mediator.
Yeah.
But for purposes of today's session, let me stick to those two because they're the most relevant.
Yes.
Thank you so much.
When you say international lawyer,
Yes.
what does it mean?
I mean that's my specialty in terms of practicing the law. My major is in international law. That means that I've tried to major on matters international law.
All right.
Yes.
I actually have a question. It's a bit off.
Yes.
Off from what, I
Our
think
topic of discussion.
it's inspiring to see women in
Yes.
law. You know, that's what my dad wanted me to be. And sorry, Dad, just not my cup of tea. I wasn't that smart.
Law. Yeah.
But, just tell us the space of women when it comes to law. How is it received, having been there and having the experience?
Yes, there's a lot of misconception when it comes to lawyers, girls in law generally. Sometimes someone looks at you already, they have a conclusion. This person is really argumentative, or this person has already formed a conclusion, or this person is opinionated, or is really strong, or maybe if you're looking for a partner, this person cannot submit. No, actually, it's just a profession like any other, and especially for women, because now it's a patriarchal society. When you empower the girl child to understand the law, it's like you're telling the girl child, move away from how you were supposed to be. You're supposed to be quiet, reserved, following orders. And I'm not saying it's wrong to follow orders, and I believe in submission, and I believe that we have gender roles, we have like things that men do because of their nature, and also things that female, God created them in a certain way so that they can be able to perform certain duties like nurturing, caring, taking care of the home. I have no doubt about that. But there's just this misconception about lawyers, especially the females, that goes around that is not really fair. Once you get to know someone, you get to understand their personality, who they really are. Yes.
Is it something you always wanted to do from when you were a child?
Tricky question. I think that is, I started off with wanting to be other things, but then I think I'm dynamic.
Okay.
By the time I was finishing my Form 4, I think this is where I found my niche. But even as I was progressing with my career, I ended up deviating towards ADR. So you see, I'm still work in progress. I'm still a student of life. Yes.
All right.
Awesome.
To our topic of discussion this morning, and we are talking about mediation.
Yes.
If you could, for purposes of laying the foundation for us, the difference between mediation and arbitration.
The difference between mediation and arbitration, maybe just to set the pace first behind, just like a background. We have the alternative method of dispute resolution. We have the main system, that is the litigation process, whereby people go to court, you file a case, then you're subjected to the trial process, and then you defend your case, you present evidence and witnesses. That is the court process. It's a bit rigid and adversarial. It could take time and money also. But then we have the alternative methods of resolving issues. Like, for example, like you've mentioned, we have mediation, we have arbitration, we have conciliation, we have negotiations. But just to stick on the difference between mediation and arbitration, when it comes to mediation, we'll find that we have a third party who comes in to assist the parties to resolve issues without necessarily making the decision for them. That means the mediator is not an adjudicator. An adjudicator simply means a person who decides. That is a judge. Yes, like what you see in court.
Yes.
You present your arguments, but then at the end of the day, the judge makes the decision, which can either favor one side or the other side. Yes, there's no favoring both sides. But then with mediation, you'd find that the parties themselves are the ones who come up with their own solutions. It's a process that is for the people, by the people themselves, with the aid of a third party. So that is mediation, whereby we have a win-win situation that is arrived at in a confidential process without necessarily involving outsiders to come and make the decision for the people. But then also it has other benefits, which I'll talk about later. But then when it comes to arbitration now is whereby it's like you've just simply removed the judge from a court. Now it's like a private setting. I'm not saying it's the same judge. No, there are people who've been trained as arbitrators. So what usually happens is that now this person in the name of an arbitrator comes in, and then the same arguments are presented to that person, but then now this person is the one that decides. So it's still a bit adversarial in a way, but still it's better than when it comes to now a court process whereby it's public and then everyone can follow up. It's a bit private now because it's just restricted to the parties who are privy to that session, either through the representatives of the parties themselves, and then now the arbitrator now make the decisions for the parties. Now that's the difference in terms of who makes the decision, how they take place. So in an arbitrate, when it comes to arbitration, it's now the arbitrator who makes the decision. When it comes to mediation, it's the people themselves who make the decision. So that is the clear difference. But then when it comes to arbitration now, it's like you've removed parties from the courtroom, you've taken them in a private place. Otherwise, the same the rigidness of the court process is not like done away completely, because still you have to follow like certain procedures. You have to, lay your case, present your arguments, and then leave it to a third party who, like now in a more private setting. So that is the difference. Yes.
And I'm thinking about it, and I feel like mediation is actually biblical.
Yes.
Because there's a part, I don't know where.
Yes, there's actually a verse that says that parties should first try to resolve their issues amicably before going to court.
Yes.
Because when you go to the court, your relationship will be injured.
That's true.
Definitely.
That's
true. You will not remain friends.
Yes.
And then
switches
you will
things,
find that it's one person takes it all. The other person has lost everything.
That's true.
So I don't think it's a fair process to go through that process. Still a way to obtain justice, but I don't think if you're looking towards mending relationships, if you want to resolve your issues in a faster way without involving a lot of costs, and just saving effort and also other issues that become inconvenience you in a way, then mediation will be a better approach. And if it fails, then you can proceed to the court.
And maybe
you feel aggrieved in a way. That's the reason why you have differing opinions on a subject matter. Yes.
And maybe on the same, you can also talk about now the benefits of the mediation process. Aside from it being biblical, it's good to also get to the nitty-gritties of the facts also. Like, what are these benefits that maybe you have observed from mediation?
There's so many benefits. In as much as I'm a lawyer, an international one at that, it's funny because not all lawyers will tell you this. So
there are others who prefer.
We all go to law school. We all go to law school, and we're taught you represent your argument, and then the best person wins. The best person with the best argument who has presented their client before the judge, and then now the judge decides. But then when it comes to mediation, I'll start with the very first one. It mends relationships. You've seen even blood brothers kill each other because of land, because of very simple things that build up over time. So when these issues build up over time, you'll find sometimes even the present day issues are not the actual issue. You'll find this issue started a while back, but because you've not had that time to even just sit down, just engage and get to discuss about these things, you'll not really know what is really the root cause. What what is actually the background towards maybe perhaps our different interests.
Yeah.
And I think mediation, apart from mending relationships, also saves time. It's a very fast process because sometimes you have matters that have stayed for 30 years in court, or maybe you have a continuous feud with people, a community, or even if it's maybe even companies, or even maybe you've defaulted in a bank, you've not paid your loan. And, you know, you'd still wish to relate with this bank. So you can't really just take that person to court. That will mean you'll sever those ties, you'll not want to engage them afterwards, after the court either rules in your favor or theirs. You'll just be left with the opportunity to now appeal. But now when you come to the mediation table, you get to see people's emotions.
Yeah.
You get to see and understand their background. You get to interact with them in a closer perspective from, you know,
Right.
just what you see in court. You know, in court is just the law and evidence, and that's it.
Yeah.
You don't get to engage with people one-on-one to understand their background, where they're coming from, the challenges they're facing. So that is another benefit of mediation, whereby, number one, it maintains relationships. Number two, it's a bit faster. Number three, it saves on costs and also time, you know, like I've just said. And also you get, like I've said, you get to see that softer version of this other person in terms of allowing this person to be vulnerable so that they can even disclose some of their inner issues that maybe they can't do so in a public, maybe court. And then also you see that it's a bit confidential. That means that only the parties that are privy to those maybe perhaps you know, differences are the ones who are present, or maybe they are representatives if it's a court and it's mediation session. But if it's a private mediation session, then we'll just find the parties themselves who are the ones who decide for themselves being present there. And therefore it excludes other people who are not privy to that. And then you'll see your issues will not get out there. Like, why should I know that George or maybe Beatrice is facing something? You know, you just resolve your issues privately. No one gets to hear about the same. And then also, if it's court annexed mediation, it's tied to the court. So whatever decision you arrive at is again adopted by the court, and then it's enforced by the court. So it's recognized, it's adopted, and then it's actually enforced by the courts as a, you know, a judgment. That is if it's court annexed mediation. But if it's private mediation, you'll find that the parties themselves, you have the autonomy of the parties. That means that the parties themselves get to decide. So in other words, you've not denied these people the opportunity to explore all possible angles. It means that these people have been given that opportunity to look at their issues, to actually engage each other, and to brainstorm together as a team, because it's about teamwork. In as much as it's a voluntary process, if it's a private mediation. So the parties come about, you know, they get together and they get to explore all possible avenues within which they can be able to arrive at an amicable settlement. So because they're the ones who've taken a direct lead role in the negotiations, they tend to even follow the agreement even more, rather than just a third party in the name of an adjudicator who comes in and imposes a certain outcome on you, and you're forced to comply. If maybe you feel you don't want to comply, then you're left with the other alternative route you have to follow is just to appeal. So you'll find that with mediation, if it's private mediation, it's a bit faster, it saves time, and then you get to have your issues in a confidential way. And then also, it's also in as much as you're saying it's alternative, you get to be creative. Yes, you get to be creative, because you see in the courts, it's about the law, like I said, it's about evidence, it's about representation. But then when it comes to mediation, we can be creative. I need to understand your interests. What really do you want out of this process? Like, what really are you looking towards achieving? Like, in as much as you have maybe the issues that you'd want to be addressed, and maybe I also have my issues that I want to be addressed. We'll have to put things on the table. We look at the possible outcomes, we look at proposals, we look at the best way in which you could be able to compromise a bit. Not to say that now it's one side who takes it all and the other one is disadvantaged. We are simply saying that you come together, you look at what you're willing to take and what the other person is willing to take, so that you could put your heads together and agree to a certain outcome. And by that I mean the mediator does not influence who gets what. It's the parties who come together and then they're subjected to certain rules of engagement because they understand their different roles. They're not supposed to come and keep quiet. They're supposed to be exploring so that they can be able to find an amicable settlement. So the list is endless. It has a lot of benefits, a lot.
Right.
Now, there's a thin line between private mediation and court annexed mediation. If you're talking about court annexed mediation, the advantages could be a bit more, slightly more in terms of enforcement. It's direct because the agreement is actually a court. When it's taken up by the court, the mediator simply takes that, the agreement that the parties themselves have entered into without altering anything. The court takes it up and pronounces the same as the judgment of the court. How beautiful is that? Is that the court has given you the power to be your own judges.
Wow.
So it's a good opportunity to just, try the process out, try to engage each other productively without necessarily being, uncouth. You should be mindful about the language, you treat each other with respect, you treat the process with respect. And eventually, we are not saying mediation, you must have an agreement. We are simply saying that it's a good platform to try and see whether you could agree on a certain outcome. That's the beauty about mediation. And then also it's voluntary if it's private mediation. The parties themselves bring themselves to a mediator, preferred mediator of their choice. And then the mediator takes them down through the process because now she's the one or he's the one who is in charge of the process. But then the parties themselves are in charge of the substantive aspect of mediation. By that I mean they're the ones who get to decide. They're the ones who get to, bring in the proposals. They're the ones who get to, just bring in their natural state in terms of being vulnerable, in terms of declaring the interest, in terms of negotiating. It's simply negotiating. We are saying, this is what I want. How about we look at it this way? Then the mediator, because we are trained, we have certain skills, we can be able to encourage a certain outcome. Not necessarily influence the specific outcome, but we can support reconciliatory remarks. We can be able to rephrase and reframe certain statements. Like, for example, if a certain party is really angry, if we are to rephrase whatever it is that person has said, it will be a bit calmer, the tone will be a bit better, so that this person can also see that actually this is how this person looks at it from their perspective. From my side, I can be seeing it's a 9. From your side, you could be saying it's a 6. Both of us are right. You just need another person to make you see that this person is not the enemy. And even if they are the enemy, we cannot remain enemies forever. This life is too short.
That's
just
true.
by virtue of us being alive, we constantly are bumping heads. We constantly are not agreeing, and it's healthy. How you go about addressing the different issues is now what differs, or maybe what differentiates a good communicator from another, a good peace builder from another, a peacemaker from another. Because it's not always the case that you take each other to court, you remain enemies, you fight. Yes.
All right. Okay.
Awesome. Thank you. It's a lot. You look at the benefits that you
There's
get
so many.
when you go the mediation route, and there are so many.
There's
And
so
of course,
many. I've just tried to summarize on the main ones.
That
So
was
many.
good,
And then also just maybe to add on that.
Okay.
Mediation.
Sorry. Maybe we can just hold that thought and go for a short break.
Yeah.
We are being told to go for a break.
All right.
And I'm like, okay, let's go for a break. Maybe they need to fix something, and
All
then
right.
we'll come back with that. We'll pick it up from there. Yeah.
Okay.
All right.
All
See you
right.
shortly.
Yes, no problem.
Hope TV is where you look and live, with an excellent selection of the best Christian programming consisting of local and international content, of inspirational stories, talk shows, Bible commentary, youth, health shows, children entertainment, contemporary gospel music, extended times of worship, live broadcast, news, movies, drama, Christian ministry programs, and so much more. Hope TV is another quality service from Christ is the Answer Ministries, with over 45% of authentic and credible local content every week. Hope TV is a sister station to Hope FM, Kenya's leading Christian radio station, with footprints across the country. Tune in to Hope TV, where you look and live.
as she has retained her title.
From the terraces to the touchline, we tell it as and when it happens. For all your real-time sports action, from dramas, scores, fixtures and transfers.
It's a pleasure to be here.
Join me, Mind Gimbokwa, these and every given Monday, only on Hope TV.
Right, welcome back. This is Hope at Dawn. Low Logs is the session we are having today. And in studio this morning, we are having Martha Musimbi, and she's an advocate, and breaking down the issue to do with mediation in dispute resolution. And she has explained all the benefits that you get in as far as mediation is concerned. And I think a question that maybe someone may be asking themselves is the mediation process, once you take over the mediation process and you have agreed and you have a third party, is it legally binding?
It is binding.
Yeah.
Okay, I would wish to approach that question from two perspectives.
Yes.
When you're talking about court-annexed mediation and private mediation.
Right.
Let me start with private mediation. The difference is simply the nature of engagement. With private mediation, like I said earlier on, it's the parties themselves who take themselves voluntarily to a mediator of their preference, right? So you'd say, once they have decided they prefer to resolve their issues via mediation, they themselves take themselves to a mediator. That's the beginning of the mediation. That is private mediation. Now, what comes out of that process is an agreement. That is a settlement agreement that has been arrived at from private mediation. It is binding, and it can be used in a court of law. Like, for example, if one of the parties breaches that agreement, that is still an agreement by itself. Yes? So now when it comes to court-annexed mediation simply means that we have ongoing court matters. These are real-time cases that have been filed by persons, right? So you'd find that the court usually screens matters for mediation without consulting the parties. So the court just looks at the matters depending on how maybe perhaps it deems them fit for mediation, and then it refers them automatically to mandatory court-annexed mediation. So that means the parties don't get to decide whether we want mediation or not. The court simply says it has ordered this matter to be resolved through mediation. It does not mean that you must agree. It just simply says try mediation. And if it fails, then come back here. Because the court has looked at the facts, they look at the, perhaps how you presented the case, and it feels like, the court has a lot of backlog. We have a lot of cases that have been there for a long time, and still more are coming in. So to try and fast track that process, some matters are usually referred to mediation, court-annexed mediation. And then now the difference is that when now there's a settlement, that settlement is now taken up by the court. It's legally binding. The court now takes it up and pronounces it as the court's order or judgment. And then it cannot be appealed. That is the difference. So when it comes to court, that judgment stems from the mediation sessions.
It cannot be appealed.
It cannot be appealed.
What if now, as a party to the mediation process, I feel I'm not satisfied,
You're not satisfied
with what happened?
with what happened.
Can I now forego the mediation process and now resort to legal court process?
Okay, let me just
The
ask.
same case.
Let me ask.
Yes.
Do you mean after they have already,
Yes. So we have exhausted and completed the whole mediation process.
Yes.
But
Was
at
there-
the end of it,
Yes.
I cannot appeal anywhere,
Okay.
whatever they have said. Can I resort to court process?
Do you mean after they have already gotten an agreement from the court-annexed mediation sessions? Now, you see now, the answer, to answer you, the answer is no. Why? Because the court deems as though it has given you the opportunity to actually take an active lead role in the negotiations. So court imekwambia, you go to mediation, you've been there, you've been actively negotiating, you've even endorsed that agreement, your signature is there, and then a month later you're saying, or maybe a year later, you're saying, I don't want this agreement. Now, that one, unfortunately. That's why we usually say, it's a very serious process, yet it's a bit flexible.
Yeah.
Because it's a solution by the people for the people. The people arrive at the solution that is for them, that has been arrived at by themselves for their own good.
Yeah.
So you've not involved a third party in the name of an adjudicator, an arbitrator, or a judge
Yeah.
or a magistrate to decide for you. Then how again are you saying, I am not comfortable with this agreement,
Yeah.
yet you are a direct party? So
Okay.
unfortunately,
All right. All
no.
right.
And maybe are there examples of
Yes.
maybe situations or cases
Yes.
that one should opt for the mediation process?
Okay, very well. To answer that, not all cases can be mediated.
Okay.
Yes, not all cases can be mediated. Like, for example, sometimes we have, sexual offenses, rape, we have murder, we have manslaughter, we have robbery with violence, mostly criminal cases, sometimes public interest cases, sometimes when there is a very huge power imbalance. Like, for example, there are some matters when maybe it's the government that is involved. When it comes to mediation, just to answer you, when you're coming to the mediation table, we have rules of engagement, right? So there ought not to be any power play. The parties need to sit down. They need to, respect each other regardless of their status.
Yeah.
And also they're not supposed to leave. They agree to just come and try mediation. They try to negotiate. So when you're trying to negotiate and maybe there's a higher power that maybe you'd find one party feels like maybe they're, given a raw deal, or maybe they cannot be free to just perhaps air their issues out, their interests. So you'd find that matters that are of a criminal nature cannot be mediated because it's an offense against the state. We have republic versus so and so. That's the state that is after you. So matters that are actually criminal in nature, public interest matters, sometimes very serious matters that maybe involved very high authorities simply cannot be mediated.
Right.
But then we have matters that can be mediated, like, for example, civil matters. All civil matters, except the ones that I've just talked about, can be mediated. Like, for example, we have family issues, we have children, we have matrimonial issues. By that I mean matrimonial property, we have succession matters, we have conveyancing, like land, for example, we have insurance law, we have issues to deal with, maybe commercial issues. It cuts across. We have international matters. We have
Divorce.
issues that come from, yes, divorce. We have, but when we mediate divorce, we're not telling you, oh, come together. We're simply telling you, in the event that you've decided to divorce now, how do we go about the aftermath? We have children involved. We have property involved that has been jointly acquired, or maybe perhaps there's one person that came with the property prior to the marriage. So, these are very sensitive issues that can actually be so, they can just get out of hand. And you have innocent people, like, for example, children. You don't want to subject children to the court process whereby they are the topic in the limelight. We have a better way to do it. We can just have a very quiet session. We try to engage each other productively. When we actually are seeing the benefits of the process, I usually start by informing the parties the benefits of the process, just trying to, just tell them what the process is about, what to expect, their different roles, the rules of engagement, what is expected from them and myself, the court, if it's a court annex process, if it's a private session also, so that we don't really waste a lot of time. And also I get to understand them, I give them a forum, so they give their opening statements, and then we start to talk about the proposals. And more often than not, the parties are usually open to mediating once they see how beautiful the process is. Because even personally as a mediator, I am bound by certain ethical rules and code of ethics. I cannot just talk about your issues. Like, for example, if I've met you privately, once I'm done with the session, I've forgotten. Like, really, not literally, I've forgotten. I can't really talk about you. And also we have certain skills, like I said, we expected to have certain qualities, being empathetical, just listening to you, giving you that time, being patient, trying to direct you because I understand the law. So I can tell you, even if you go to court, this is how it's most likely to turn. And it will turn like that. So you will remember me. Not to threaten the parties, but really it's just a way to let them see that this is the way to go. And if you try and it fails, well and good, you can just proceed back to court. No one is really pushing you to agreeing into something you're not comfortable with.
Because the next question I wanted to ask you is, you're mediating between Watare, Beatrice, and
and
George.
you, yes.
George is willing to go the mediation route.
Must
Yes.
you say I'm the one who's not willing?
But
Okay, let's assume
yeah, but
Beatrice is not willing to go the mediation
yeah, the
route.
mediation
Or I'm
route.
willing and Gigi is
All right,
not.
she's
Either
willing
way.
and I am not willing
Yes,
to go the
yes,
mediation
chances
way.
Yes.
are.
How do you convince Gigi to,
Yeah.
to come on board?
Yeah.
Because I may be saying,
Unataka
Mimi,
koti
Unataka
na
koti.
mimi
I have my lawyer.
nataka.
So
Okay.
why are we engaging in this whole
Yeah.
mediation thing?
Okay.
Yeah.
What happens?
I'm going
by the
to
way?
answer you from two perspectives. Number one, if it's private mediation, unfortunately, that's the dead end. If you're not willing and the other side is willing, it's a voluntary process if it's private mediation. By private, I mean if it's now obtained as an alternative method of dispute resolution outside the court
Okay.
process. Because you see, court annexed mediation stems from the court.
courts.
It's an umbrella of the court, right?
Yeah.
So if it's in the context of court annexed mediation, unfortunately, whether you want or you don't,
not.
you still have to come.
Yeah.
We are saying the court has ordered court annexed mediation because it has screened your case. It has not necessarily even consulted you.
Yeah.
Because sometimes
Yeah.
you would find parties would request the court by themselves
Yeah.
for court annexed mediation.
Okay.
But in the event that the court screens matters and then it deems your matter fit for court annexed mediation, you don't have to necessarily agree to mediate.
Okay.
The court is just saying you have to try.
Yeah.
So
Yeah.
when you come to the mediation table, the mediator reaches out to you. It's not really a must for you to agree. You could just come,
Yeah.
listen, you try. If it doesn't work or you don't see like it's maybe in your interest, it's taking your interest into, perspective,
Yeah.
the way you want, and maybe you feel you're most likely to benefit from the court process. You don't mind the delays and the cost implications.
Yeah.
So you're free to go back to court. No one really would tie you and say you must agree.
Okay.
Yeah.
Because also with agreement, it can be a partial agreement. It can also be a full agreement. It's not always that parties agree on all the issues.
Yeah.
Because
Right.
from the beginning, we usually come up with a case summary, whereby we list the issues, maybe just a brief background of the case, and then we have the issues to be determined during the mediation session. So not all those issues must be determined.
Okay.
Yes.
All right.
So you could even find someone who was not willing to come for mediation within the context of court annexed mediation ends up eventually agreeing to some of the issues. So you would find maybe on issue number 1 or 2 you are agreeing, but on issue number 3 to 10 you don't agree. So you're free to go back to court.
Okay.
At the end of the day, you've made the process faster for yourself.
Okay.
Because if a matter was to take 3 to 5 years, you've resolved it within a week.
That's true.
So it's a very good process, if you ask me.
All right.
Yes.
Yeah, and maybe now we have just a few minutes,
Yes.
but maybe you can talk to someone just directly, to someone who maybe has never even heard of the mediation process,
Yes.
and they've never even thought about it in terms of settling a dispute, and
Yes.
just what you would say to encourage them to actually go the mediation way as opposed to moving forward with the court
The
thing.
court process. Okay, like I said, this is just a personal view.
Yeah.
Personally, I usually advise people, even clients, to try resolve issues amicably first through ADR, alternative method of dispute resolution. But then if it fails, then we can proceed to court. But then somehow there has not been proper sensitization and advocacy on matters ADR and by extension mediation. So most parties assume the only way to get justice is the court process. And I mean, it's a very also a rigorous process, and it's also a way of obtaining justice. That's just the truth. But there are faster, more effective ways of even getting that justice. But then it goes down to what actually is the subject matter. Like I said, not all matters can be mediated on. So number one, I'd wish to know which matters perhaps they have, what their interests are, if they don't mind the cost implement. There are people who are just stubborn also. And there are people who are a bit, they would be open to trying new things. Because even mediation, the sensitization of mediation is a bit new. The mediation process has been there for a while. Even court annexed mediation is it came recently, 2016. It wasn't there previously. So it was a pilot process, and now I think it has been embraced, and it's now in most counties in the courts. So to someone who is not aware of mediation, it's actually unfortunate because there needs to be proper sensitization and advocacy. But for the people who are listening to me today, I will tell them mediation works. It's a solution for you by yourselves. So you could try it. Just try it. And how do you get mediators? They're all over. I'm one of them. And I would understand maybe they don't know where to start.
Yeah.
And sometimes you go to your lawyer. If they're not also well versed, they might not necessarily encourage ADR. But there are lawyers who are pro ADR and they will be willing to encourage you or maybe even give you a legal opinion and tell you this matter can be resolved. Because even with litigation, it starts with a demand letter.
Yeah.
You don't just go to court directly. You are told if you don't comply with this and that within X number of days, we are going to go to court. So if this person is willing to comply, that means that's where you bring in mediation. And that's also a good way to generate income for the lawyers. They come in and they write an agreement which binds them, and then they are forced to comply. But in the event that they're not willing to take that up, now unfortunately they have to proceed to court. But to that person who is not aware about this process, now you are aware. Mediators are there, you can search them, and also some mediators are lawyers. Not all mediators are lawyers, but we are here to help the people. And the people are the ones who benefit the most from this process because they are the ones who take part actively in the process. They save on time, they save on money, they build their relationships. It's a confidential way. And then also you get to be vulnerable. You get to understand the other person's perspective with the aid of a third party who has no interest whatsoever.
Yeah.
If I had interest in a certain matter, I would actually just recuse myself. Yes, because of ethical reasons. If I know you personally, there's no way I can be objective because I'm supposed to be objective. I'm supposed to be neutral. I'm supposed to be empathetic. I'm supposed to be professional. I'm a person of integrity. I should not just take up matters and I know I'm compromised. So mediation is a very professional way. And in as much as we have the alternative justice systems, like for example, we have other ways apart from the formal ways, like I mentioned, arbitration, conciliation, mediation, and negotiation. Sometimes we have others, like for example, since time immemorial, in our African system, we had the elders, we had the chiefs. We have the way we used to resolve issues at home, there in the village. So those systems are still there, the alternative justice systems. So those are informal ways. Maybe they're not trained to address issues objectively, but somehow they still used to work. The only disadvantage with that is that sometimes they could be repugnant to justice and morality. You'd find like maybe people are mediating rape, not really mediating. They call it, let me use, for lack of a better word, let me say negotiating. The alternative justice system, so whereby we have the chief and maybe perhaps the elders, they come together and they're negotiating things that should not be negotiated. FGM should not be negotiated. Murder should not be negotiated. There's no amount of cows that can bring in lost life. That's a criminal. So you see, in as much as we have the alternative justice systems, not all of them are embracing what is legal. But with ADR, it's actually a formal way to just resolve issues amicably within the parties, specifically mediation. Yes.
Martha Musimbi,
Beautiful.
and she's vast. You can tell, and there's the
Very.
passion.
The zeal.
Yeah, the zeal.
And the
is there.
The zeal, the zest, the passion, the satisfaction.
Exactly.
Yes.
When it comes to
Beautiful.
mediation.
Yes.
And by now I know that you are enlightened, and that is the route to go in as far as mediation and resolving issues are concerned. And she also was able to highlight some of the cases that can be resolved through ADR, and also those cases that cannot be mediated through that mediation process. Thank you so very much for your time. Thank you for sharing your wisdom as well with us this morning.
Thank you so much too. I feel like even the time is so
I know,
limited.
I know,
feel like
so
continuing.
limited. Yeah, we've just started. You know?
Just scratched the surface.
Yeah.
Yes, I was just starting.
Imagine. You are laying the foundation.
I'm trying. I'm still laying the foundation.
We'll definitely do a part 2 next time. But thank you so much for coming through. I've learned a lot. I think my biggest takeaway has been, you still get to maintain those relationships. I think humanly it's impossible to have peace when you're not at peace with people. It's difficult. Even when we can pretend and have our hearts hardened, it's still a bad thing, especially to someone who is close, a friend, even maybe a relative. So I believe that the fact that it keeps those relationships still going, it's beautiful. And the fact that it's actually biblical to have those conversations before deciding to go to court. So I've been able to learn so much, but we've come to the end of the show. Time is far much spent. But yeah, thank you. Thank you, our dear viewers, for staying with us and for keeping us company. My name is Beatrice Watare. See you tomorrow.
Right, and my name is George Kishoro. Tomorrow being Tuesday, also we continue with Hope at Dawn, one day at a time. From us here, it's bye-bye for now.